Now, Fred Logue, your firm has taken more judicial reviews than any other legal firm in this country. I'd be right in that, would I?
Well, I acted for clients have taken more judicial reviews than any other firm, yeah.
Now, maybe before we get to the substance of this, could you just explain to us what is the controversial move? What exactly is the government doing in relation to who can take a judicial review?
Well, I think you have to ask an earlier question. So like the planning system is a decision-making framework for development and land use. And it affects everybody. It affects how our environment, it provides a basis for society. So these are really important decisions that affect everybody, you, me, our families and our friends. So of course the public should be part of that decision making. That's a fundamental aspect of it. And what that means is that the public can know about decisions, they can make observations, and they have a right for those observations to be taken into account. Now the idea of a framework is that there's rules and laws around it. And therefore there's a right of access to justice to make sure that the laws are followed. And I think it's critical that, the reason why we have judicial review is it's a key part of environmental protection. So it's essentially the crowdsourcing of environmental protection.
OK, but what exactly is being done here that you object to?
So what the bill proposes is to restrict who can take cases and what type of cases they can take.
OK, so if I'm in, say, a residents' association and I have an issue with a development beside me, what would change under this legislation for me? Well,
for example, if your association had less than 10 members, you might not be able to take the case. If your association had a large number of members, they've made it much more difficult for you to decide to take the case because they require a 2/3 vote, for example. So there's no reason why we have to have these restrictions. So these are put in as kind of effective barriers for people to try and organise and take cases.
And there's another element about how long that association has to be constituted and has to have a constitution.
Yeah, there's other elements like that. But the bottom line is we actually have a decent enough system now today that everyone really kind of understands, and it's working quite well. And there's no evidence that I know that I've seen. But
it would be bad news for you if this changed. If fewer people could take judicial reviews, it would be bad for your business.
Well, as I always say, bad legislation makes weak cases strong. So if the legislation kind of overreaches and imposes restrictions that are unlawful, then people will just turn and start challenging the legislation itself. Or even if the legislation is in breach of EU law, the courts have to disapply it. They can't apply Irish legislation that breaches EU law. So there's a very thin line that has to be trodden to have decent access to justice legislation that provides for people's rights but doesn't restrict them, because in effect if the state or the government tries to bring in legislation that unlawfully restricts rights, then it will actually create more litigation than it tends to.
I want to let Michael O'Flynn answer this, because do you lobbied for this, right, this change?
To suggest that we have a system that works is just extraordinary. We have a broken system in this country. Let's be clear, the system doesn't work. I absolutely understand and respect people's rights, but we have the most onerous system of planning in Europe. Like, it is extraordinary for people to say that this works. It doesn't work. We have a housing deficit in this country of probably 300,000 units. And the government are doing good work in providing housing for all targets in terms of some of the initiatives they've brought in. I want to acknowledge that. But the housing targets we have in Housing for All are probably half what we need. We have a deficit of 300,000 units. We have a deficit of rental units. And we need to get real here if we're going to talk about the issues. We have a third-party appeal system that is at the root of this problem. And let's be clear about this. The third-party appeal system, people are appealing the principle of development. The principle of development are decided at the national planning framework, regional strategies, county development plans, local area plans. And guess what? You can turn up and take an appeal on the principle of a development. I have absolutely nothing against densities. I'm all for the compact guidelines. But the judicial review system is we are now giving planning by lawyers, with due respects to Fred, my colleague on the panel here. Planning is for planners. It's not for lawyers. And the sooner, like, this planning bill has some pluses in it, But this is going nowhere towards dealing with the issues we need if we're going to house the unhoused. I'm here to speak. I just want to finish. The unhoused people should have a say in this country. We are failing a generation of people. We have a system that's broken, Katie. We need to face up to it. We need to fix it. We need to pause this bill and get this bill right.
Ironically, actually, in the last 3 years, the judicial review system, the judicial system is the only part of the planning system that actually functioned. We had the SHD legislation, which is the worst piece of planning legislation.
This is the strategic housing legislation, which was to fast track.
It was so-called fast track. It cut out the local authority stage. It was a one-stage decision. It allowed the development plans to be bypassed. It allowed the NPF to be bypassed.
It's been dissolved. No, that's not correct.
It is absolutely correct.
No, let's be frank about what's correct.
The judicial review system, people took judicial reviews and they succeeded at a rate of 80 or 90%. So that means 80 or 90% of those decisions should never have been made. So that is not a delay in housing. That is a dysfunction elsewhere in the legislation, as we've seen, and in the governance.
Some of those decisions make no planning sense whatsoever. We have the legal system taking over the planning system. We have issues being sent to Europe that could be resolved here. So your description of SHDs, and I take exception to it because it's not correct. It needed tweaking. It didn't need to be.
Come on, 90% of them are the judicial reviews are succeeding in the courts. Are you saying the courts are all wrong?
Well, I would have a serious issue with how a lot of the SHDs were dealt with in the courts, and I have good reason to say that. But that's an issue that needs serious debate now.
There's plenty of developers taking judicial reviews, which,
I mean, the SHDs, it's now large-scale residential developments. But if I could just mention very briefly just about the bill, this is a new legislative framework. It would deal with proper spatial planning and sustainability across national, regional and local areas. And just in relation to the judicial review, I'm a lawyer myself, Fred, and I have great respect for your profession, but I don't agree with some of what you're saying, to be honest. If you look at the bill itself and what we're doing in relation to judicial review, the leave now to apply to the High Court to bring a judicial review is gone. We have the new the environmental financial legal costs assistance scheme, which will help people in terms of a contribution. It's means tested, they can get legally aided. And the residents' associations, they do need good governance when they're bringing a case, so that you don't have spurious claims.
Can I just put you though, because it's not just Fred, because people might say, well, Fred has skin in the game in particular, but there was academics in this area, environmentalists. Many people came before the committee that were looking at this legislation, and this was an issue many people across the board had with it, and it was. They said it was cutting the city. It was diminishing citizens' rights in terms of their participation in the planning process.
We have a really proud history in this country of public participation, and it's so important that this particular bill, was compliant with the Aarhus Convention, with that we take the EU directives into account. We're balancing so many different rights into public participation, consultation. You have the residents' associations. You can actually 3 times make a submission in this country, whereas a lot of countries you have to be directly impacted before you can actually.
But that doesn't make it right.
No, and I'm just saying that you can actually, that the public do have a right to make a submission.
A right, but not 3 opportunities. You just
they do have 3
times.
Opportunities. They do it at the application of the planning stage, they do it at the appeal stage, and they do
Eoin Ó'Broin has been very, very patient here waiting. Where are we on this?
It's really important when we have these discussions that they're kind of evidence-based, right? Because sometimes when I hear some of the public debate around planning, it doesn't actually bear what's happening on the ground. So the first thing, every year planning permissions are granted over the last bunch of years for between 30 and 40,000 new homes. There are planning permissions right now that haven't commenced construction for over 100,000 homes. So not everything in our planning system is broken. I'm not saying there aren't things that need to be improved. I'm not saying there aren't problems. But there is a very, very significant number of planning permissions that have been granted and not commenced. That's the first thing. The second thing is, I suppose I'm a little bit lucky in that I sat through 30 hours of really, really detailed expert testimony to our committee when we had the draft scheme of this. So specifically on the issue of judicial review, and I would like to see less judicial reviews, right? Because for me, when something goes to the courts, it means something hasn't worked somewhere else in the planning process. But not only did the country's leading planning and environmental legal professionals from the Bar Council and the Law Society tell us that they believe that the government's intention here was to restrict people's access to the courts. For me, the more concerning testimony was they said it would not work. What they actually said is these sections of the bill would have the very opposite effect of what Mike is looking for. They told us that would increase litigation, including satellite litigation and litigation to superior European courts. That would lead to even further delays. So, obviously, as responsible legislators, and we do want to work with the government to get this bill right, we're trying to work our way through what is a very, very technical piece of legislation. My fear is at this stage, and some of this will become clearer as we go through the bill, is that in an attempt to restrict people's access to the courts where people have, whether legitimate or illegitimate concerns, they actually make the process more conflictive, more litigious, and therefore subject to even more delays. It will be a very, very big mistake. And for me on this, I want to hear the experts. And the other testimony that we heard in committee that was really, really strong was the Irish Planning Institute. Now, so for people who don't know, the Irish Planning Institute are a very cautious bunch of people. They represent public and private sector planning officials. They represent the people that Michael employs and local authorities employ. They said to us exactly the same thing. Both this section of the bill and other sections which we'll come to have the potential for more conflict, more litigation and more delay. And if that happens, our planning system...
No, I don't agree with that. And one of the primary aims of this bill...
But Minister, you're saying you're not agreeing with academics. No, but can I just put to you, you're not agreeing with the academics, you're not agreeing with the lawyers, you're not agreeing with the planning...
One of the primary aims in this legislation, and Deputy O'Brien knows this, is to make sure that there's more clearer language, to avoid duplication, to avoid complexity, and to streamline and have more cohesion. And there will be an opportunity at committee stage for every party to put down amendments and to discuss this. This is the most ambitious piece of legislation raised into planning in almost 25 years. Okay. It's taken 15 months of intensive scrutiny to try to get it to shape, to help future generations and to have that end product that David talked about, which is a house and a home to live in.